So I will take you now through the 12 steps of GDPR compliance. They're recommended by the government, and I will give you some handouts. And this is the handout which I will give to you. Please share them. And we'll be discussing these 12 steps. So I created these 12 steps that match the government instructions. So we'll go one by one to explain them. So this is the leaflet which you will receive, and I will go through them now. So the legislation is officially starting, it has already started, but the deadline for the legislation is 25th of May 2018. So some companies wait until the deadline, some companies don't wait until the deadline. So hopefully all of you will be able to say that you're GDPR compliant before the deadline. So the first step is building awareness. Well, congratulations, you're already here, and this is part of your awareness. This awareness should be built to you as directors of companies, but also this awareness should be built to your staff. And I will give you some options later on to explain how you can build the awareness about GDPR to your staff. So the second step is the information you hold. So you have to very carefully divide the information. Typical solution is categorization. So you can categorize different information you've got within the organization, and you have to be really clear what you've got, what is the purpose you obtain this information, how you're using this information, how long do you keep this information, and if required, how you can remove this information. So you have to be really clear. And my experience shows me that once you go through this exercise, you really understand that there is so much information you don't really need. It's been accumulated during the years. It's been accumulated from server to server, from project to project, so you don't really need this information. A typical situation was when I was working with a estate agent. We found that they've got some information on properties which were sold ages ago. So they are not working with these properties anymore at all. And they don't need this for business reasons, they don't need this for legal reasons, they don't really need this information. So you have to really consider the information you hold. So the next one is communicating privacy information. So you have to really review your privacy notices. So the privacy notices should be really clear. And there are really good articles on the internet where you can see some examples of privacy notices. So here it shows how it should be done, what is correct and what is incorrect. So you have to clearly display your privacy information, and it must be readable. And for example, in this case, it is very clear form when somebody can complete the form and they can check the boxes and the font is nice and clean and everything is done really properly. With this one, it's so much more difficult to read. So this is not really compliant form. So with these ones here, it explains clearly why you should give the information. And this explains here what is the outcome of choosing of giving the information. This element here. So here there are wrong elements. So this document is downloaded from the ICO website. You can go there and get similar example to see how you have to present the information. So number 4 is individual rights. So you should check your procedures to ensure they cover all the rights individuals have, including how you delete personal data and provide data electronically in its commonly used format. So if you collected already information, the people who provide you with the information, they should be able to access the information if they require so, but also they've got the individual rights to ask you to remove the information. And you have to be able to remove it easily. And preferably, they want to be able to remove it automatically. You must have seen some emails where you click on unsubscribe, isn't it? You click on unsubscribe, and then these emails very easily are being deleted. So the next one is subject access request. So you should review your current privacy notices and put a plan in place to make necessary changes time for GDPR. Really, you should be doing this now. So different people, they've got different rights to ask access for their data. Number 6, it's a lawful basis for processing personal data. So what do they really have to give you, and how do you protect the data, and how much data do you collect? Because you have to collect the data only what you need for a particular project, and keep it as much as you need it for a particular period of time. It's not necessarily for you this data to keep it for a longer period of time if you don't need it anymore. So the next one is consent. So when you collect the data, you have to get exclusive consent from the people, whoever gives you the data, and you have to prove that you got this consent and agreement from them to use the data. I will give you some particular examples later on. At the moment, this is just the general regulation in principle. Talking about the children, if you're dealing with children, you have to seek assistance from the guardian or from the parent, and children data is very particularly saved, and under no circumstances you should advertise anything to children, for example. So what is the children's age under the GDPR regulation? Any ideas? Yeah, you're absolutely right. The children's age is 13 years old for the purposes of GDPR regulations. So the next one is data breaches. So the question is not will there be any breach? The question is what will happen should you have data breach? So in that particular case, you will need to report, and you will need to report in a particular way to the Information Commissioner's office, and what will happen there, nobody knows. But surely the ICO will not be happy for the fact that you've got data breach. And in fact, there is a bit of a rumor going on at the moment. And the rumor goes like this, that because it's a public register, ICO will accumulate this information, and we will be able to go and see all this information at some point. So usually when we run business, if you want to work with a supplier, what we do, we just go and check their credit rating, isn't it? And if the credit rating is good, we work with this supplier, we give them a credit line, and we can work happily with them. But if you notice that this supplier hasn't got, or this client hasn't got a good credit rating, you don't really want to work with him, or you want to give him a very small credit line. So this particular case about the data breaches, they say it will become something similar. So if you decided to work with somebody, you will be able to This is a rumor, we don't know yet. And you will be able to go online and check how many of these data breaches this company had. So now you turn the tables around and you think, so if you have number of data breaches and you reported the breaches, obviously they will go to a public domain on the ICO website. Who will want to work with you if you had so many of these problems? Of course, there is a way around it, so you can lie. So you never report it. So the obligation is to report it within 72 hours, of data breach. And there is, of course, always an option to lie. And this is what Uber did back in November last year. So they had attack, and they lost several millions personal details for several millions data for several million clients. They lost. So they kept it quiet, and they went even a step further. And what was the step further was they went to the hackers, and they said to them, "I will give you $100,000. You just stay quiet and don't tell anyone what happened." So this is what the hackers wanted. So hackers went to the media, and everybody knew that Uber was penetrated, and also they lost all this information, and they got into deals with the hackers. So lying really is not an option, and I do not recommend. So you must report the data breach within 72 hours of data loss. And also, you have to tell all the parties, including your clients and suppliers, whoever was within this database of data loss. The next one is the data protection by design and data protection impact assessment. And this is where comes most of our services. Because when we design computer systems, and when we design websites, and when we design big databases where all of your data is held out there, it is very much important to protect the data by design. And I've got many examples here, which I will show them to you in a minute, how to protect the data by design, so you can keep records. By the way, is this interesting? Yeah, it's good? Very nice. So the next one is the data protection officers. So what is the data protection officer? The data protection officer is a person within the organization who is familiar with the Data Protection Act, and he knows the escalation procedure, how to report it to the Information Commissioner's office. In other words, the data protection officer is the hub for all information that is coming regarding GDPR within the organization. And do you need one? Do we need one? Who needs one? Because it's another full-time job, isn't it? And there is no strict instructions, but the rule of thumb says that if the company has 50 people or more, it's very likely that they will need a data protection officer. So for the rest of the companies, you might opt in, for example, for a virtual data protection officer. What is a virtual data protection officer? The virtual data protection officer is a person that is not working within the company, but he is familiar with the company data structure. He knows the legislation, or she knows the legislation, but it works for external company, and this is fine. So they're kind of a consultant who comes now and then, and this is the focal point for any data protection reports. So the next person we should consider, it could be the data protection administrator. And what is a data protection administrator? The data protection administrator is a person within the company that does something else. So it could be one of the engineers, it could be the accountant, it could be project manager. So this particular person is familiar with the GDPR legislation. He knows the policies and the procedures. He does the training and he does everything within the company, but is not a particular job just to do this particular job. And the difference, the legal difference between the data protection officer and the data protection administrator is that the data protection officer has legal responsibilities, and the data protection administrator hasn't got legal responsibilities. So when you assign somebody into these roles, please make sure that it is the right person and they understand their responsibilities. So the next point and the last point, which is number 12, is the international. What does that mean? The international means that any company that trades within the European Union has to be dependent on this GDPR compliance. Let's say there is a company in America that sells goods in the UK. Do they need to be GDPR compliant? Ideally, yes. And do they have to go through the entire process? Ideally, yes. But if they don't want to do that, at least they have to take particular measures and reasonable steps towards protecting the data in terms of their clients and their suppliers. So this was more or less 12 steps explained. You got all the handouts for this, and if you have any questions, by any means you can ask me now or at a later stage.